Okay.
Hello, everyone. I'm Lou Pirro of Pirro, Connor and Strauss. To my right, your left, is Peter Strauss of Pirro, Connor and Strauss, and we're here today to talk to you about a topic that is very important to us and hopefully to you as well, and that is special needs planning. In the United States, 1 in 5 residents has some level of disability, and that is not something widely known. 20% of the U.S. population, 50 million Americans, live with a disability. Obviously, some are more severe than others, but all need careful planning. And the truth is that we don't know when that person may be us, because disability can onset at birth, it can onset in old age, and it can onset anywhere in between due to accidents, illness. And so when we do special needs planning, we have to look at all age groups from infants on to seniors. And I'm very happy that Peter Strauss is here with me today, one of the foremost experts in special needs planning, who's been doing it for a few years. And Peter, can you tell our listening audience what is special needs planning?
It's advanced thinking and making decisions about what happens to yourself or a child or a parent or a spouse if they have an illness that renders them unable to manage their financial affairs, can take care of themselves, make medical decisions. And generally, the client that calls us may be about a child with disabilities and say, you know, we take care of Billy now while we're alive, but what's going to happen to Billy when we're both dead? And there may not be another family member to take on those responsibilities. So special needs planning is the legal documents and looking at how we pay for long-term care, because you may be surprised to find out that Medicare will not do that. And if a child gets Social Security disability and then 2 years later gets Medicare, that Medicare is not going to be the financial solution to the significant costs of long-term care. So special needs planning is the documents, the system, appointing appropriate trustees, trusted people who can manage this plan once we work with you to define it and implement it.
So Peter, the common goals of special needs planning, balancing the present needs of the person with a disability and the future needs of the family. And it becomes more and more difficult to secure good housing, to make sure that that housing can be adequately paid for, to ensure that there is a quality of life and a standard of living that is something that is what the family seeks for the member with the disability. And so we want to make sure that everyone gets on board with the plan, that parents and children are on board. We like to do documents that we're going to talk about to make sure that the plan is memorialized adequately, that it's financed properly, and we want to make sure that we're reviewing it periodically as circumstances do change.
So let's look for a minute about the risks if you don't do this. If you say, I'll get to it later. Well, you may not have time to get to it later. You may become incapacitated, have your own medical health problems, and may not be able to do the planning. And the consequence of not doing it is that there may be the need for the appointment of a guardian by a court. There may be fights among the siblings later on about who should be the guardian, who's going to have control. You may find that the court would appoint someone as the guardian or substitute trustee, perhaps even if you had a trust, if you don't spell this out, who would not be the person that you would have chosen. And you may not have your goals carried out. So the planning in advance, well in advance preferably, is a way to avoid that kind of risk.
That loss of control can devastate families when all of a sudden there's intrusion from people who have different goals and different outlooks and are not serving necessarily the best interests of the person with a disability as the family sees them. And when you go to court, it's also extremely expensive. Any court proceeding ends up with multiple attorneys. You have legal fees going in several different directions. And if you plan properly, you can keep your loved one and your family out of that predicament, out of that court situation. So, Peter, what are the steps in special needs planning that we should be looking at?
Well, I think we need to first identify what the plan is going to be. We can't do the legal and financial planning until we have helped you decide on what the care plan is going to be. Is the disability of a child such that the child will need to be in a residential facility? You may be caring for this child at home. You're not here any longer. Where is that child going to live? What is the care plan? What are his or her needs? And we need to identify them.
And we do that in a document we refer to as a future care plan. And we have samples of that document that parents use to lay out basically the future of their child. Because even though we may do a legal plan, if that plan isn't an informed plan with the goals, wishes, preferences, desires, what does the individual like to do? Where do they like to travel? What do they like to eat? All of those things, if it's someone with a disability, become quality of life issues. And the future care plan, I think, is the vital document to make sure that families have laid that out sufficiently.
And in developing that future care plan, we will work with you to speak to your professional advisors in the medical and social service fields, any organizations that have been assisting you in caring for that child. And that helps us and helps you create a plan that really is workable and makes sense for your particular situation.
And then the legal plan dovetails with that, and that's going to be either a will, which would create documents like a special needs trust, or you might use a living trust. We're going to talk about each of those in some more detail. And then you want to make sure that the financial elements are talked about and covered. Is there sufficient cash flow? Life insurance may come into play. You may want to have some additional cash go in upon your passing. If you cannot provide services to your child with a disability, then you have to quantify those services and make sure that there's sufficient liquidity to be able to provide those things. Parents undervalue themselves, Peter.
Absolutely. And part of the future care plan is defining the costs to carry out the plan that you think is appropriate for the child or any other family member, and then figuring out how you're going to fund it. And we'll talk a little bit later about using life insurance to fund the trust. But we also want to spend a little bit of time with you now about government benefits. But first, a little bit more on the difference between a trust and a will.
A quick aside, when you have someone with a disability and you have to probate a will, there's a separate section of the probate petition that their name goes on. And once you have put someone on that side of the probate petition, person under disability, then the court is going to look at that and appoint someone to represent their interests. And we call that a guardian ad litem. And my experience is, Peter, this takes twice as long as a normal probate when you have a guardian ad litem and reports that have to be filed.
Yes, I mean, a will is one way to do it, but when you create this trust under your will, to some extent, you're asking for future difficulties, both in terms of getting the will probated, and there's great delay there. And if both you and your spouse are no longer living, to implement the plan, if it's done by funding through the will, may be a very unwise thing to do, which brings us to the better planning through a living trust.
So in either case, what you're going to look at creating for the individual with a disability is called a special needs trust. And as Peter mentioned, we're going to talk about government benefits, the two primary being Medicaid and Social Security or supplemental security income. And we want to make sure that the individual has ongoing eligibility because both SSI and Medicaid have resource and income limitations. So you can have families create plans for those individuals with disabilities. We'll talk about the different types of trusts. But what you want to make sure, Peter, is that the family's resources are protected and preserved and available to the individual with a disability to fund that future care plan, but not to jeopardize the government benefits.
Correct.
that they otherwise
the
have.
last phrase for you to understand is most important, but not jeopardize the ability to have government benefits, which are means tested, which is SSI as opposed to Social Security Disability, which is not means tested, or Medicaid, which is certainly means tested.
So people generally come into the system either because of a disability from birth or some disability that has onset later in life, and that could be due to illness, disease, or accident, injury. And when you have a disability and you have been working and you've established a work history, then Social Security has a benefit that you have paid into already, and you're then able to tap that benefit, and that's called Social Security Disability Income. And Social Security Disability, or SSDI, it's very critical to distinguish between the two, does not have income and asset limitations. So you can have other income coming in, you can have assets and still get SSDI. With regard to that, once you've been disabled and been determined disabled for 2 years, you can qualify for Medicare, and that's the basic health care benefit. Unfortunately, Medicare does not cover any long-term care services that a person with a disability may need. And so we need to go beyond Medicare into the realm of Medicaid. Peter?
Well, and Social Security and supplemental
security income.
So SSI, as opposed to SSDI, is basically welfare for the aged, blind, and disabled. It's a welfare program that the federal government rather, took away from the states many years ago and relieved the states of providing this kind of financial care. And you get a monthly stipend if you're eligible, meaning you don't have more than $2,000 in resources and your income is below a certain amount. You then get a cash distribution, and it is supplemented by New York State. So roughly you can get about $840 or so of SSI payment. That automatically qualifies that beneficiary for Medicaid. But that's not the only way you can get Medicaid. If you're not eligible for SSI, you can file with New York State through the local county Department of Social Services, and you can get Medicaid because you are disabled. And Medicaid pays, it's a basic fundamental health insurance program, and also covers the long-term care costs to some extent that Medicare does not cover. So it may be a part of the solution of funding the care plan that we have talked about earlier.
So again, just to distinguish, because it is so important. And Peter, when we work with clients initially, the first document that we ask to see is the Social Security award letter, because many people don't know exactly what the benefit is. Some people actually receive both disability and SSI payments. And so you need to have a clear delineation of what the benefit is and how it's being provided and why it's being provided. And you can get from Social Security that award letter, which will lay all of that out. It's a fairly substantial, several-page letter that gives us clear guidance. And it's so important to identify up front whether it's SSI or SSDI, and then we'll go ahead from there and lay the plan out accordingly. So, Peter, in planning for people with disabilities, one of the major pitfalls is if you leave assets to them directly, then they fall squarely in violation of the eligibility rules.
Right. We need to be very careful to counsel you to look at all of the assets that might be available to provide for the care of a child with disabilities. And that means you don't want to have an insurance policy payable directly to that child.
Or an IRA.
Or an IRA.
Or a 401k.
Or a joint bank account.
Transfer on death account.
And so just having the trust may not solve the problem. You've got to go beyond that and fill in the details and make sure that those benefits pour into that supplemental needs trust that we're going to be creating for you.
And why don't we go ahead, Peter, and you have a long history with this and have been involved from kind of early stages in the creation of supplemental needs trusts, especially in New York and the statutory trust that's there. Why do special needs trusts exist, and how do they benefit a person with disability?
Well, remarkably, unlike the usual methodology of the Congress of the United States in being very antagonistic to poor persons and disabled persons, Congress back in 1993,
Over 93,
decided that children or persons with special needs did need some special protection. And they carved out of the rules that say if you have assets, you're not eligible, and you can't usually give away those assets if you're seeking nursing home benefits under the Medicaid program. Congress said these persons with disabilities can create a supplemental needs trust, which is often referred to as a first-party supplemental needs trust, or a, quote, self-settled supplemental needs trust, meaning the money of the person with disabilities, that you can put that money into a special supplemental needs trust for the sole benefit, that's a very important term, of that disabled person. And that money can be used to improve the quality of their life through special benefits that are not covered by Medicaid or Medicare, provided that they were under 65 years of age at the time they created that trust, and provided that at the time of their death, any money left in that trust is to be used to repay the state of New York or whatever state you're in for the Medicaid outlays during their lifetime. Now, there may be nothing left in that trust, in which case there's obviously no payback. No other family member has an obligation to pay that money other than those funds that are in that trust.
So I remember attending a bar association meeting after Over 93 was passed that you might have spoken at. And although it was one of the most well-meaning and well-intentioned pieces of legislation, I think your comment was that it was drafted by the four horsemen of the apocalypse.
Yes.
Because there are many restrictions on the statutory special needs trust, and something that we refer to as a D4A trust. And so we're going to get into a little bit of that detail as to how and why these things work. But the bottom line is that if you give the trustee the authority to use funds for purposes that will support the beneficiary, but that will not supplant, but rather supplement what is otherwise available from Medicaid and SSI, then the money is preserved within the trust. It doesn't go directly to the beneficiary. It goes to providers, to vendors. Very often we even use a credit card where shopping can be done, and then the trustee can look at the credit card bill on a monthly basis and pay those items that are appropriate for special needs trust payment. So there are a lot of details that go along with that, but the bottom line is when you do this properly, the money in that special needs trust is not countable. Medicaid is available, SSI is available, and they can continue. So why don't we start to break down the trust a little bit, Peter? Who are the parties to this trust?
Well, in the first party trust, where we're talking about using funds that shouldn't have been left outright to the beneficiary by grandpa, but now you have $100,000. Grandpa's will left $100,000 to grandchild. Grandchild is disabled. We're stuck. We have a problem. We resolve the problem by putting it into a self-settled or first-party supplemental needs trust, created now by the disabled person or his parent or grandparent or guardian or court, perhaps. But the law was changed just about a year ago to allow the person with disabilities to create his or her own trust, which was a great breakthrough for us. So you put that money in the trust. That person would be the grantor or donor of the trust. And then you have to have a trustee. You do not want to have, you cannot have the beneficiary as the trustee, because that might result in it still being counted as belonging to him, and he or she would be ineligible. And he is the beneficiary. So those are your fundamental parties to this.
One of the critical elements to creating a special needs trust is choosing that trustee. And parents often struggle when they're doing this for a child Should they use another family member? What you should never do is leave money to one child and say, well, they'll take care of their brother or sister. That is so commonly done and such a misconception, because those funds could be out the door faster than you could say jackrabbit. And that could be because that person gets divorced, they die prematurely, they go bankrupt, they have a lawsuit. So you can
buy a lot of tickets at Saratoga
racetrack.
Right.
Yeah. And, with the opioid crisis, so many people today are at risk there. So you have a lot of risks just leaving money to a child and saying, oh, they'll take care of their sibling, or leaving money to anyone and thinking they're going to make sure it's going to be used for the other. Even the best intentioned person can't control certain elements of their lives that may take those funds out of commission. So we want to create a trust. Now, you can certainly have the other children be trustees of that trust where the funds are safeguarded for the benefit of their sibling. You may also want to consider having a professional trustee, a corporate trustee or trust company. And you have a lot of experience.
Yeah, or a combination of both.
Combination.
Sometimes if there are two other children who do not have medical issues, you could have those two children with a bank. Because, that if you only have two children to be trustees, they could not agree on expenditures. They could be sometimes concerned with spending that money. If there's anything left after the child dies, they might be inheriting, and therefore they have a sort of very subtle, or maybe not so subtle, conflict of interest. So sometimes having either a bank as sole trustee or a bank as one of two or three trustees may make sense. And there are more and more banks today that are becoming very sophisticated about these trusts. We'll accept them, but one of the problems is that banks have minimum requirements for accepting an appointment as trustee. I don't know of a bank really in New York now that will take one for less than $500,000.
It depends on the relationship that the family has with the bank.
And the location in the state, perhaps.
Yeah, but that's generally what the minimum is going to be. Some are $1 million, some are $2 million, but $500,000 is very common. We do have a bank here locally in the Capital District of New York. Peter mans our New York City office full-time. In Capital District, we can get it down to $250,000.
Interesting.
So we work with some good trustees. The three types of trusts: first party, so the disabled
we've talked about
individuals' own assets go in. Third party, meaning the parents are creating the trust or a sibling is creating a trust. I had a special needs trust for my mother in my documents in case I predeceased her. Money would have been set aside to support her in her home. So it can be done for a lot of different people on a third party basis very flexibly. And then there are pool trusts, which we're going to talk about. You've been talking, Peter, about the self-settled trust.
Correct. But we need to spend a couple of minutes on this first, on the third party, the one created by a parent or another relative. And this makes it clear why you need to do this planning in advance, because the first party trust may be the default because you didn't do the planning. You didn't talk to grandpa about changing the beneficiary designations, or you didn't do it yourself. With the third party trust, one, it's more flexible. You can spend money on more things than perhaps the first party trustee can do. Secondly, there's no payback. The money that the parent puts aside in a third party trust for the child can be used for things that are a little broader than what the first party trust. And then when the beneficiary dies, that trust is undiminished by a payback requirement. So that really points to doing this planning now rather than having to cure the problem later on.
So you might wonder what this one was that I skipped by, the pool trust, which came in 1993. And yeah, you can do the math. We've been around a while. So in 1993, this first party special needs trust, the statutory trust, or the D4A trust, has a lot of different names, came into the law along with this pool trust. And the pool trust initially was just a group trust. So if you had $50,000 and you wanted it to be protected and preserved and still be utilized for an individual, you could use the pool trust concept. And what happens is you would contribute that $50,000, and the trustee is a given. You choose the trustee, and it's a not-for-profit entity that's running that pool trust. And we have several in New York, large ones like the NYSARC Pool Trust, We use the Teresa Foundation Pool Trust very frequently, which is based down on Long Island. But there are some wonderful trusts and trustees, and the money in that trust doesn't go to the state at the end, it goes to the charity. So you can support a charity that administers the pool trust if there's any money left at the end of the day. But again, the pool trust, like the first party trust, doesn't come back to the family, it goes to the charity. If you have larger sums of money, you probably are going to use an individualized trust. The pool trust, even though you're pooling money, you have a segregated account. So your $50,000 would be administered separately. You would give bills to the pool trust trustee. They would then pay the bills on behalf of the beneficiary, and only, again, it's sole benefit. So it can only benefit the beneficiary. But these have become very useful for people who don't have trustees that they can rely on.
And the amounts may be not large enough to have a bank. And one other advantage of the pool trust is that for self-settled monies, you can use a pool trust even if the beneficiary is over 65, because the limitation on a self-settled trust is you have to be under age 65. But the escape hatch for that is a pool trust could be used for a person over 65.
And we've been using pool trusts in another context, that is Medicaid planning for Medicaid home care for people over 65 who have the need for chronic care. And when we apply for Medicaid home care, you can use the pool trust to shelter their income over the Medicaid limitation. So that $862 a month limit is not such a firm limit, because the pool trust can receive the excess income. And again, you hand them bills, they pay the bills. So you keep use of that income. And that was a wonderful change in the law a number of years ago.
And there's one other point I want to make here about third-party trusts. If you don't have family members and there isn't enough money to use a bank in these cases, some of the not-for-profit organizations have what they call community trusts. They are not classically Medicaid trusts, but they're like pool trusts. I actually created some of them before 1993 for some not-for-profit organizations, and they still have them. So if you can't find a trustee, you can open an account in one of these community trusts, and that may also fit the needs of some of you.
So ideally, you're going to create a living trust, and that can be a trust for yourself or an irrevocable living trust. And upon your passing, you're going to have that flow right into a third-party special needs trust for the beneficiary. No court involvement, no guardian ad litems, no probate of the will, and you get a clean third-party special needs trust, fully protected for the beneficiary. And the beauty here, Peter, is when that beneficiary passes, it can go to whomever you choose. It could go, if they have children, it can go to their children. If they don't, it can go to your other children. It can go to any of your family members. And that really is the benefit, one of the primary benefits, as we said, of the third-party SNT. We talked about selecting a trustee who's appropriate. Family member, yes. At least a co-trustee who is a family member who can make sure that the needs of the individual are being met. Financial advisors typically cannot act as trustees, so that necessarily will not work. Attorneys, some do. We don't particularly seek the appointment as trustee, but sometimes other attorneys will take on that role, and advocates sometimes take on the role of third-party trustee. But again, family and corporate trustee is probably the best team, because you get the professional management of the assets, the accounting, the tax returns all prepared by the corporate trustee, and you have the family member to ensure that that future care plan is being carried out in accordance with the family's wishes.
And we create these trusts with language that make it very clear that the trustees can hire professionals such as professional care managers and social workers and psychiatrists and psychologists that may not be paid for under the Medicaid program, so that you can really accomplish your goals. Now, funding.
Well, financial planning considerations. We have about 3 minutes left. You want to make sure that you have adequate funds, adequate liquidity pouring into this trust. If you're funding it with a retirement account, it presents special challenges, because you can't have what's called a conduit trust. Gets a little technical here. You want to have an accumulation trust. So that has to have really a standalone, individualized trust to be the beneficiary. So we work with retirement plans all the time, and you want to make sure that the designation is proper and you have the right kind of trust to accept that retirement plan. One of the principal ways that families fund this, if they don't have sufficient liquidity, is using life insurance. And that can become an integral part of a plan for future care planning to make sure that, as Peter said, the economics of the future care plan are going to work throughout the lifetime of the beneficiary.
Correct. And one other point on the life insurance, even if there are some sufficient assets to fund the supplemental needs trust and care and provide for your other children, sometimes you may feel that the needs of the child with disabilities are greater and you want to leave a larger amount. Using life insurance to create the funding for that larger share is a very good solution to the emotional and family concerns that may come up when you want to leave 75% of your estate for the one child with disabilities and a smaller amount to the others. You can perhaps equalize that with life insurance at a relatively inexpensive cost.
Absolutely. So we'd be remiss if we didn't mention ABLE accounts, Peter. And these are fairly new, 2014 onto the scene of planning for people with disability. Just a thumbnail sketch of ABLE.
Well, ABLE is a new concept that's similar to the custodial account or the trust for the account for the benefit of a minor. Perhaps a little better. They're modeled after the 529 accounts, but they're similar. And you can put in over a period of time up to $100,000. And they're not countable. They're not considered gifts that would make, well, it's your money, but they're not countable as belonging to the beneficiary to adversely affect their eligibility for Medicaid. So
they're tax advantaged. You get to grow the money tax deferred,
right,
and pull it out tax free if it's pulled out for a qualified individual. The $100,000 is a limitation. There is a number on your screen there that's an old number, and I apologize for that. $14,000 is now $15,000 per year that can be contributed. But ABLEs are a good supplement. They're a good way to put money aside. You can move money from other types of accounts like Uniform Transfer to Minors Act accounts into ABLE accounts. And it's a great way to have money protected yet available under the rules similar to a first-party special needs trust, but with a little added advantage because you get to use tax deferral and ultimately pull the money out tax-free if used for a qualified beneficiary. So they're new, they're available, something that you may want to consider funding and consider doing it in conjunction with your special needs trust planning.
Particularly where you have money in custodian accounts or trust for minors accounts, which become available when the child becomes 21. The ABLE account money is not countable at age 21. So even though there's a payback provision, maybe you'll spend that money during the child's lifetime and you won't have to worry about the payback.
Right. So if you have a family member with a disability, or if you have a disability yourself, careful planning is absolutely the word of the day. And we think that you can do a great job planning for someone who has that disability with a careful future care plan and special needs trust plan. Make sure they work in tandem because you want to make sure their needs are met and that the finances are controlled and available to them, but that their Medicaid and SSI benefits are going to be preserved long term. And even though they may not need substantial amounts of Medicaid today, as needs changed and housing requirements for an individual change, they may need that Medicaid down the road. So it's very important to preserve those benefits.
And you will know that you are, to some extent, relieved of the concerns and fears about how this beloved family member will be cared for.
So thank you for spending half an hour with us, Peter. Thank you for joining us today. If you would like to get more information, log on to pirolaw.com. We have a resources page. We have a special needs trust guide that will help you to get organized and a questionnaire for special needs trust planning that you can utilize to put your thoughts together and put pen to paper and start the process. The enemy of planning is procrastination. So make sure you start as quickly as possible. And if you'd like to meet with Peter, in our New York City office or with myself here in Albany or in New York, please email us, info@pierolaw.com. info@pierolaw.com. Thanks again for joining us. Peter, thank you. Hope you have a wonderful day, and we hope that you join us for all of our future educational programs live online. Thanks.